This is a screenshot video of the first posting for weeks 3 to 4 in the Introduction to Law course. Disregard this information about posting 5 because the source material for this posting comes from another course. So we're weeks 3 to 4, posting 1, screenshot video 1. I think this is going to require me to do at least 2 and possibly more than 2 screenshot videos to get through this material, but this will get us started. Before I do, however, I want to point out today's date is September 18, and by now you should be finished looking at the material in the first 2 weeks and be working on the first quiz, which is 10 questions worth, I apologize, 5 questions. Let me get this straight. 5 questions, a few true and false, and then a short answer question. And it's worth 5 points. So this will get us started with some evaluations. In any event, the material that we're going to start to go through now, sources of the law, I asked the question, where do rules of law come from? Where can they be found? And our general answer, at least in terms of sources of the law in the United States, is that a law or a legal rule, if you will, is going to be issued or found in or traced back to the Constitution or some judicial decision or some legislation or an executive order or proclamation or some kind of rule from an administrative agency. And this is where we're starting from in terms of sources of the law. And what we're going to do is we'll go through each source. We're going to be spending quite a bit of time on judicial authority, and I think when we get there you'll see why. Not quite as much time, at least for now, on the other 4 sources. I might add, and I know that this course, the Intro to Law course, is not a paralegal course as such, but if you decide to take courses in the paralegal curriculum, we have a 3-hour course in constitutional law. So if I seem to be very general in talking about the Constitution, and if you have an interest in really digging deep into it, that would be a good course for you to take in the future. And I note when we talk about constitutional authority, that we could place it at the top of the list because all of the other rules of law in our U.S. legal system must be consistent with the Constitution, or as it said, those rules would be null and void on the ground that they are unconstitutional. If we wanted to look at examples of constitutional authority, we could look at the Bill of Rights. And I'm speaking now, of course, of the U.S. Constitution, and the Bill of Rights is commonly thought of as the first 10 amendments. And I point out that the right to free speech under the First Amendment would be an example of constitutional authority. Let me suggest, it's not in the notes, let me suggest that in the next decade or so, one of the battles in constitutional law that will be fought out is the extent to which a person can rely on their First Amendment right to the free exercise of religion to avoid complying with civil rights legislation banning discrimination against people's sexual orientation. And I think some of you may have heard of the case that the court kind of ducked the first time around about a baker who didn't want to bake a wedding cake for a same-sex couple. I'm not offering any opinion, and my take on that personally, of course, would be irrelevant. I'm just pointing out that's going to be something that we'll be seeing. I also point out, and this is significant, that the Constitution is not self-executing. And and Madison is spelled wrong, and shame on me because I typed this. It's Madison. But beginning in 1803, some would argue before then, but certainly 1803, the Constitution was interpreted by the Supreme Court in Marbury versus Madison, and most significantly, the Supreme Court said that it had the power to interpret the Constitution, and that indeed the ultimate source of interpretation of the Constitution rested with the United States Supreme Court. If you were to read the text of the Constitution, including Article 3, where judicial authority is mentioned, that would not be an inevitable conclusion. But that was certainly the interpretation offered by the court, and it's remained in place, that interpretation, up to the present time. The other fact I want to point out about constitutional authority is that the states in the United States, New York State by way of example, have constitutions. And if one were working in the legal system as an attorney or a paralegal, depending upon the nature of your practice, you might, from time to time, as I do, because I do some employment law as an attorney, bump into the New York State Constitution, because that's where ultimately we find a lot of our rules about the New York State civil service system. Okay. So that's what I want to say at this point about the Constitution. So we're now talking about the second source, judicial authority. And I think that some of the statements that we could make about judicial authority are almost counterintuitive. While we might recognize judges as powerful individuals in the legal system, I don't necessarily think that many of us, when we think about the legal system, recognize that judges are actually lawmakers. The kind of wooden or pedestrian way of thinking about judges is that they do no more than apply the law. But what we're going to find out, and what I'm saying in this posting and now in this video, is that judges are lawmakers. So the question then becomes, well, how does a judge, or how do judges create the law? And I offer you two different ways. Number one, judges make the law when they interpret the other sources of legal authority. And secondly, they make the law when they engage in what I've referred to as the common law process. So what we're going to do next is explore each of these two ways judges in the United States legal system make the law. So the one way judges make the law, or if you will, create legal rules, is when they interpret the other sources of legal authority. And I point out the power to interpret is the power to create. Whenever someone or group of people is given the power to interpret a law, or I think in the case of the United States, whenever they decided that's a power they had, even if it wasn't necessarily given to them, then we have the obvious point that the interpretation itself adds meaning to that which is interpreted. Let me say that again. The process of interpretation adds meaning to that which has been interpreted. And the additional meaning can, I think, quite accurately be considered as an act of creation. So when judges interpret the other sources of authority, they are adding meaning to the source they interpret. And a dramatic example, in my estimation, of how judges make the law, and by the way, I'm telling you or suggesting to you at the very least that this applies at all levels of the judiciary, but certainly dramatic examples can be found in decisions of the United States Supreme Court. And one, I think, very good example of that is the United States Supreme Court decision in Griswold versus Connecticut. And what I point out, and again, this is not a this was good or this was bad, but simply this is what happened. And what did happen is that the majority of the court, meaning therefore the decision of the court, was that there was a constitutional right to privacy under the United States Constitution. And the court, different members of the court used different ways to interpret the Constitution to come up with that example. And I think that the perhaps controversial nature of what the court did, which was, by the way, it could be argued, add a right to the Constitution that couldn't be found there, was in a comment made by one of the dissenting judges. It's actually Justice Stewart, where he said, "I value my privacy as much as the next person, but I can't find any specific statement in the United States Constitution that there is a right to privacy." And of course, as I point out, it was this constitutional right to privacy that then led to the court's decision in Roe versus Wade. And as we know today, and this was after this text was created by me, what we know today is it also set the stage for the Supreme Court to overrule recently Roe versus Wade in the Dobbs case. But that whole line of cases, Griswold, Roe versus Wade, and Dobbs, really pitted different justices on the Supreme Court over a couple of different generations of arguing about what was in the Constitution and how they interpreted the Constitution. And what I also have earlier pointed out, but I offer you some examples, is that judges at all levels of the court system, state and federal, regularly are called upon to interpret legal rules that come from one of the other four sources. And I give you an example, kind of a mundane example when compared to the right to privacy under the Constitution issue that could arise under New York law. In a less mundane example, when I identify from statutory authority the rule in New York, or the definition in the New York penal law about attempt. So, you know, how far does a defendant have to go in trying to commit a crime before he or she is guilty of attempt? And when you look at the language of the statute, the penal law itself, it just says that the conduct has to tend to affect or bring about the commission of the crime, and that's the kind of general language that judges over the years have had to give meaning to in their interpretation, which again indicates or demonstrates, I think, better said, how judges can make the law. In my next screenshot video, we're going to talk about how judges create legal rules, make law when they engage in something known as the common law process. But I'm going to bring this screenshot video to an end now. Thank you.